Yes.
Okay.
And where is the
Who happens to be the son of the deceased?
yes?
Samrat.
Where is the CFS?
It was the last question.
Last one,
Sir.
May 2024.
Fourth June. Supplementary charge sheet file that look at June 2000.
4th June 25.
June. Supplementary. This may be earlier version.
Hmm.
That it was fine.
7th May 2025 report. Yes.
And LPG cylinder was used for assault, was badly assault, because of course within the record circumstantial evidence, the accused is a mainlander, is not a permanent resident of the site. Actually, the deceased, she engaged him to look the one beauty parlor. She was running a beauty parlor. So she made the arrangement for rented accommodation for this petitioner lordship and used to give a dinner lunch and supposed to. On that day she went there. Thereafter she was meeting. You see. Then the son of the deceased informed to his father. Thereafter went to the spot, found her own condition, and he was lying and just near of the deceased one cylinder LPG one button was used. Thereafter, investigation started after registration of the FIR. Of course, it is a case circumstantial evidence, but if there is a corroboration in circumstantial evidence, it's a good evidence circumstantial. My respect for humble submission, at least some opportunity may be given, not at this stage, every chance for absconding from this island. That is my respect for humble submission. Supplementary charge sheet is with the records. Some positive report is there. But may I say something?
Yes.
But there was, as per the case of the prosecution, they have used two instruments, that is a wooden plank and a gas cylinder for assaulting the victim. But the fingerprint experts were called. The crime scene report was also taken. And the fingerprints report experts, they have taken the chance print from the wooden plank, from the gas cylinder. Lord, may kindly see what exactly is the fingerprint expert. Lord, I'm having a copy, Lord. I'm sorry, Lord, I'm not annexed it, but I've got the reports. Lord, neither the gas cylinder nor the wooden plank. The fingerprints are matching with the fingerprints of the accused, with the charged fingerprint. Lord, there is the map that has been drawn by the expert, denoting the number of articles that was taken up for conducting the examination.
Yes, identifying.
Kindly see.
Question print mark Q1 is identical to the roll thumb impression of Navakumar
Yes.
Batu Basti, which has been marked as SPG6. SPG6 is this.
No, sir. Kindly see. T1 is the article which is matching with the fingerprint. Now, kindly come to the next page, Milord. There is the map. Now, kindly see what exactly the map denotes. What is the stove, Milord, wherein the wire is still, with the tube is still in existence.
Correct.
Milord, may kindly see the tube in the map. It is there. And they say that only two weapon of offense was there. One is the gas cylinder, and the second one was a small wooden plank. Now that has been marked something else, which is not matching the fingerprints of the accused here.
Yes. This is an application under section 483 of BNSS 2023 for grant of bail. The petitioner, the police of PS Padgaon, the police of PS Padgaon initiated the case against the petition on 1st of August 2023 for the offense under section 302 of the IPC. FIR is 302. FIR is, yes, 302. FIR is only 302.
No, 382.
Where it is?
30. It's at page number 19.
FIR
Where is that page number?
13.
It is under section 302. Chart sheet is under.
I am holding the civil bench, but I remember how to read the FIR, sir. 302 of the IPC dated August 2023. After initiation of the FIR, the petitioner was arrested on 3rd of August 2023. On the earlier occasion, the petitioner has prepared an application for bail before this court being CRM within packet DB 1 of 2024. But by an order dated 2nd February 2024, this court has rejected the application for bail with the following observation, with the following order. Page 34, second paragraph. Counsel for the petitioner submit that after the order passed by this court dated 2nd February 2024, the prosecution is able only to examine 2 witnesses out of 22 witnesses. Out of 22 witnesses. The counsel for the petition submitted that the police has also submitted supplementary charge sheet on 4th June 2025. But as per the record, it reveals that the police of PS and the Superintendent of Police of South Andaman District has received the report on 20th November 2024. On 20th November 2020. But after the receipt, the supplementary charge sheet by disclosing the CFSL report is filed only in the month of June 20. Counsel for the petitioner submitted there is no chance that the prosecution will complete the evidence of the prosecution witness in a short span of time. He submitted all the witnesses on the basis of which the police has submitted the charge sheet of the circumstantial evidence. There is no evidence with circumstantial evidence. He submitted that no purpose will be served with the accused detaining the custody and release the accused person on bail, imposing any terms and conditions. Per counsel and advocate appearing for the state submit that after the initiation of the FIR, police has arrested the petitioner, and during the investigation, it was found that the petitioner has committed the alleged offense. Accordingly, charge sheet has been filed. Charge sheet has been filed within the respective period of 90 days. Now the police has also submitted the CFSL report, which corroborates the case of the prosecution. We submitted 2 witnesses have been examined, and the case is at the stage of evidence. And if at this stage the petitioner is allowed to go on bail, there is every chance that the petitioner will hamper and tamper with this. The petitioner on the public prosecutor further submitted the petitioner is not a permanent resident in this island, and if it released on bail, he will flee away from justice. Particular counsel for the respective is this court find that the case has been initiated on 1st August 2023 for the offense under section 302 of the IPC. After the investigation, police have also invoked section Please invoke section 302 as well as 383, 382 of the IPC. IPC. It is fine that the investigation has been completed. The case is at the stage of trial, but only two witnesses have been examined. But the prosecution has cited altogether from the two witnesses in the charge sheet. This court, by an order dated 2nd February 2024, has rejected the application for bail only with the view that the prosecution will proceed the matter and will examine the witnesses as early as possible, and this court has granted time of 8 months to the prosecution for examination of the witness. But this court find that till 2nd February 2020, from 2nd February 2024 till date, only two witnesses have been examined out of two witnesses. Full stop. Concerning the above, this could find that the petitioner is incomplete since when 3rd of August 2023, and only two witnesses will be examined, and there is no chance that the prosecution will complete the trial within short span of time. Accordingly, this court find that there is a fit case wherein the accused can be employed on bail subject to certain conditions. The petitioner shall be released on bail by furnishing bond of rupees 10,000 with two sureties. One surety must be local. If on bail, he shall appear before the investigating officer on every alternative day, and he shall also appear before the trial court on each and every date of hearing without fail. And he shall not leave the jurisdiction of the PS shall not leave this island without the prior permission of till and trial court. Is not a local. Okay. CRM disposal form. CDP return. Yes. Huh? Who? So next. With appearing for the other side. Yes. Can allow it without a. Lieutenant also appearing for the all respondents to the respondents place for time to file appeal in opposition. Let appeal in opposition file within 3 weeks. In 3 weeks, the reply, if any, there to be filed within a week thereafter. List the matter before the next available certificate. What is your challenge? Huh? You are not the respondent. Mental validity of the writ petition. What is the ground of mental validity? Not the member of the free. Not the member of the okay. Yes, Mr. Beno. Yes. This petitioner is a member of the CCWS from large total heavy bodies. However, he is also a class A member of the said society. As on today,
Yes, my lord. Class A, share is there.
there is.
Now, what happened, my lord, in the year 2019, there was an election of the society. At the time of election, paper publication was made and said that you have to revalidate your membership. At that point of time, within time, they did not able to revalidate it. Therefore, their membership was not renewed for the purpose of election that they cannot cast their vote in the election. Now, my lord, by before the writ court and before the appellate court says if the period is over at this junction, you cannot. They cannot allow you to participate in the to cast the vote. Now, my lord, taking that as a speed. Now, what they are doing, they are not renewing or updating my membership.
Yes. So what you are telling? This is with regard to the election period. Tenure.
Yes, my lord. This, no, he is the member, my lord. He is the member. Now, what happened, my lord? As per the bylaws of 2004, the amendment, the bylaws is an old bylaws, I have got the bylaws. 2004, there was an amendment whereby said that the tenure of the office would be for a period of 3 years. So subsequently, in terms of the 97 amendment in the constitution, 2016, 2013, the bylaw was again amended. And after the amendment, it was said that the duration would be for a period of 5 years. Now, my lord, kindly see this document in the year 2016. A document was issued by the Andaman Nicobar administration at page 70. Now, my lord, kindly, I am just reading it, it's page number 70.
Yes.
It says, in pursuance of the communication dated so received from the Ministry of Home Affairs of the communicating the legal view opinion of the learned additional qualification general regarding delivering the proposal promulgation of the Andaman and Nicobar Act and Cooperative Regulation 2050 till the decision of the Honorable Supreme Court on the pending special petition against the order of the revision bench quashing the my lord, can you see quashing the constitutional 97th amendment Act 2011. The Registrar of Cooperative Society hereby withdraw, cancel the amendment of bylaws, that is 2013 bylaws, of concern of cooperative society which got their bylaws amended and registered incorporated the provisions of the Constitutional 97th Amendment Act 2011 which are inconsistent with the provisions. So, by this 2030 amendment which was carried by them in terms of the 97th amendment, that was
State.
yes. Now, this old bylaw to come into play. I made a representation before the authority saying that it cannot be extended because in 2019 they extended it for a period of tenure plus 5 years. The authority has asked an order to the subject matter of the presentation, page 22.
Yes, what is the reason? Kindly come to the page 22.
Absolutely law.
Page 22, last paragraph, last but one paragraph, you have cited this order number 160.
Yes, sir.
And therefore your request of issuing what is the finding? Correct. Cancelled. Hmm. Where it is?
Bylaw, can you see the 2004 bylaws? Bylaw, can you see 2004? This is in existence prior to that. Cost 20, my lord. Cost 20.
Yes.
And this is the amendment, my lord. That which they are which has been.
Take bylaws 20 supplement 1.
And this is the amended 2013 in terms of the act that state of was by the law. This again 20 suppose one says by it. This has been brought as government is the process of their amendment.
No, that's why
Clarify.
see 5 years. 21 5 years. This has been state. If it is state, then you have to govern by the 2004.
Yes.
If you govern by the 2004, it will be 3 years. This is the only question. No, the authority has said that that portion has not been cancelled, but it is the totality. It is not a. So you come with the single bench order, division bench order, and SLP. Come with that. As per the made by Mr. Rakesh Kumar, appearing for the authority, respond number 1 and 2. Case adjourned. Let the matter appear on 9th July. bylaws दे दो. Yes, next.
Constitution with regard to its demarcation, which was filed on 2nd of February 2024.
Who is appearing?
Still pending, you are not submitted, but it has to appear.
Where is she? What is your instruction? This is only the demarcation. Only for demarcation. So, can dispose of? Taken? Not taken. Okay, pass through. Pass through. Yes. Yes. What is your instruction? They are not gone to the earlier order of the court. You do one thing, you take all the bunch of the order and give to your secretaries. Before passing any order, please go through all this order and pass an order. Record an order. Item number 7. Yeah, मैं आप लोग का ये वोट नहीं आता है वो देखता हाँ petitioner has filed the present application challenging the order passed by the Assistant Secretary within bracket labor dated 16 January 2025, wherein it is held that the petitioner was negligent in adhering to the orders and directions of the management, and instead he approached the forum for his appointment in the office of his choice, which is not acceptable. And accordingly, the Assistant Secretary Labor has informed that the industrial dispute raised by the petitioner is rejected. The petition Mr. Other Shilangol, an advocate appearing for the petitioner, submit that petitioner was engaged as daily rated Mazdoor in the Andaman and Nicobar Public Department by an order number 145 dated 8 March 2025. And since then, 2021. And since then, he was working in APWP as director. He submitted that in the meantime, the petitioner has been relieved from the office of the executive engineer, Port Blair subdivision, APWD, with the direction to attend the duty at electricity department. Full stop. is contended that neither the electricity department and it is contended that the electricity department not allow the petitioner to report the duty. Subsequently, when the petitioner approached the APWD department, APWD, but the petitioner was not allowed to perform the duty. On the other hand, the oh, on the other hand, the APWD has allowed some other three persons to remain in the APWD as 3 or 2 other three persons to allow to continue in the Andaman Public Work Department as daily rate and mazdoor. But the request of the petitioner has been ignored. Finding no other alternative, the petitioner has preferred, has filed a complaint before the Labour Commission, and accordingly a proceeding has been initiated. But the proceeding initiated by the Labour Commissioner ended as failure. The Labour Commissioner has communicated the failure report to the administration for taking decision for referring the matter to the Labour Court for taking decision. But instead of referring the matter to the Labour Court, the Assistant Secretary has passed the impugn order rejecting the claim of the petition. Counsel for the petition submit that the impugn order passed by the Assistant Secretary Labour is against the law, and she could not, and the Assistant Secretary Labour cannot pass the order holding that the petitioner deciding the claim of the petitioner without referring to the Labour Court. Per contra, an advocate appearing for the administration submit that under section 12 within bracket 5 of the Industrial Dispute Act, the administration has the power to decide the issue, and accordingly, on receipt of the failure report from the Labour Commission, the administration found that the claim of the petitioner is not liable to be sent to the Labour Court for any decision. Accordingly, the administration, by invoking the provisions of section 12 within bracket 5 of the Industrial Dispute Act, has rejected the claim of the petitioner. Had the learned counsel for the respective parties peruse the materials from the court. This court find that the petitioner has raised an issue before the Labour Commissioner, as the authorities are not allowed to perform his duty as delegated mazdoor, and per contra, the authorities have allowed their his counterparts continue as a delegated mazdoor in the APWD department by ignoring the candidature of the petitioner. The Labour Commissioner to settle the issue has called for the report as from the APWD, but the matter was not settled. Accordingly, failure report has been forwarded to the administration. Industrial Dispute Act का है. Once the failure report has been reached to the administration, it is the duty upon the administration to forward the same to the Labour Court for taking decision. But instead of the same, the administration themselves have decided that the claim of the petitioner means the administration themselves itself have rejected the claim of the petitioner. Considering the above, this court find that the decision taken by the Assistant Secretary Labour by rejecting the claim of the petitioner instead of sending the matter to the referring the matter to the Labour Court is against the law, and in terms of the order passed by the Honorable Supreme Court in the case of Bombay, State of Bombay versus KP Krishnan, reported in 1961, Volume 1, SCR 2027, wherein the Honorable Supreme Court has held that the discretion was vested in the appropriate government as to whether a case for reference was made out or not could be answered in the light of all relevant circumstances which could have been bearing on the merit of the case. far as the scope of judicial review of an order passed under section 5 of the Industrial Dispute Act was concern, the authority has to see whether they are able to decide the matter or is to be referred to the labor. This could find that the dispute raised by the petitioner is to be decided by the labor court upon evidence of both the parties. And as such, the keeping order is set aside. The administration is there to take appropriate steps by notifying, by forwarding the case of the petition to the labor court by way of notification within a period of 4 weeks from the date of receipt of this order. WPA number 776. Next. Who is for the petitioner? On the last occasion also he has not come. The third occasion. Seeks accommodation. None appears on behalf of the parties. As per the prayer of the petitioner. Yes, what is the matter?
Grant of electricity.
So,
On the
forest land. Is there any report in the forest land? Is there any report in the forest land?
But the letter has been issued to
Who?
by the assistant AG.
By which letter? Assistant engineer. What is the name of the petitioner? To Jila belong. Application sent to Tehsildar, so verify the survey number. Not received any report from the Tehsildar regarding the land of his state. You have not received any report from the Tehsildar. How you can say that the forest land? And how you are again sending the matter to the Tehsildar for an NOC? You are allowing the corruption much more than once the matter has been settled by the full bench. Again, you are giving the authority to the revenue authority for taking the no objection from the settled possession of the proper certificate from the Tehsildar. It is nothing but to give the hike in the corruption. Who has told you? You are not in from the authority. Why they are sending to the Tehsildar? What is to be seen by the electricity department at the time of electricity connection? Then set up will decide. Your engineers are blind. What is the settled possession? What is the meaning of the settled possession? Residing there, having a long tenure over the property. That's all. So why you are sending to the Tehsildar? I will call this person or your superintending engineer. When she will available to come here?
I will.
What when the full bench judgment is there, for that purpose only the full bench set in the circuit bench at Blair, it has to be decided. Only you have to see, and your engineer has to see on the basis of the affidavit. If you find the affidavit is wrong, you take appropriate steps. But you cannot call the report from the Tehsildar. And how many reports you are getting from the Tehsildar? On how many days?
They are getting the no electricity to be granted.
So whether they can say? Petitioner is not here. Mr. Satish Mishra is appearing for the administration. None appears on behalf of the petitioner. It is fine from the record for the last several days the petitioner is not appearing in this matter. However, for the interest of justice, the case is adjourned, let the matter appear tomorrow. It is made clear that on the tomorrow, the petition failed to appear, appropriate copy of the writ petition will be disposed of accordingly. Give the instructions, sir.
Sir.
Your engineer go and see. If they are not, you take a decision. Why the Tahsildar?
Sir.
Tahsildar having so many work.
Sir.
And Tahsildar is going to spot. You show me any of the case, Tahsildar is going to spot. That's what I'm telling. Yes. Yes.
Yes, simple question is that we have submitted general corporate money which was notarized.
Hmm.
But as per JERC regulation 5.30, it should be registered. Registered general power of
Of?
JERC regulation.
Show me the regulation.
It is there. I have already.
JRC है. General power of attorney of whom?
Registered.
Recorded text.
5.30.
If my employer giving my on the basis of I give the house over there, studying there. So
5.30.
5.30. Second clause, registered general power of attorney.
But as per the Registration Act, power of attorney is required to be registered. As per the Registration Act, power of attorney is required to be registered. See section 17. Seventeen to 43, I think, some Registration Act. Huh? That is different. That I have not touched that area. This is with regard to they are asking for the registration. Okay, this has been. See, even in the if a person, if a tenant intends to take the electricity, only what is there no objection either in the affidavit or by way of power of attorney. Registered power of attorney, why?
Here in the prayer regulation, that's why. So that may be clarified.
Any of the following: registered power of attorney, municipal tax receipt. If suppose here the encroacher, what they will produce? What they will produce? Even if it's not received the it's affidavit, undertake it. You evict the illegal occupier through the process of law, but the water and electricity cannot avoid. Yes, but you take instruction.
No.
The petitioner has filed the present application grant of electric connection. A grant of electric connection in the land, in the residential premises. In the residential premises, standing on survey number 559/2, facing an area of 200 square meter, out of total area 0.3100 hectares, situated at Ramakrishna Gram, Diglipu, under Diglipu Tehsil, North and Middle London. Consider the petition submit that the petitioner is the power of attorney holder of the recorded tenant. Recorded tenant, namely P.L. Armugam, son of K. Palaniappan, who is the recorded tenant of the aforesaid landed property. Counsel for the petition submit that being the power of attorney holder of the recorded tenant, the petitioner has applied for grant of petition has applied for grant of electric connection in the dwelling house standing on the said survey, standing on the said landed property. Full stop. The Mr. Satish Mr. Leonard, appearing for the electricity department, Andaman administration, submit that the petitioner has applied for grant of electric connection in terms of the power of attorney of the recorded tenant. But as per JERC regulation 2018 5.30, if the occupier intend to obtain electric connection, and relied upon the power of attorney, the power of attorney has to be registered. But in the present case, the petitioner who has applied for the electric connection as a power of attorney holder of the recorded tenant, the power of attorney is not a registered document. And as such, the department has not provided electric. Full stop. The Registration Act আছে কি? Registration Act as per section 17 of the Registration Act, power of attorney is not necessarily not required to be registered necessarily. Full stop. However, the electricity department has relied upon the JERC, which has been promulgated in exercise of power conferred under section 181 read with section 50 of the Electricity Act 2003. The electricity is the essential service for the Charna project. Full stop. It's the full bench of this court has decided that even an illegal occupier is also entitled to get an electricity if he is in settled possession of the property. In the present case, it is not disputed that the petitioner is not in occupation of the premises in question, but only the dispute that the power of attorney is not registered in terms of 5.30 of the JERC. This court has considered 5.30, the JERC, which reads as follows. Yeah, कर देना. None. It's just a name. Good stuff. In the said provision, in proviso, it is mentioned that provided further that the electricity bill shall be only for the electricity supply to the premises occupied by the consumer and shall not be treated as having a right or the title over the premises. In the present case, this court finds that the original owner has given the power of attorney to the petitioner to obtain electricity. And there is no dispute that the owner has not, the recorded tenant has not given the power of attorney. And as such, considering the above, in my view, the it's not necessary that the power of attorney should be registered for applying the electricity bill. In view of the above, the respondent number who? Respondent number 2, Assistant Engineer Estate Department, Diglipu, is directed to provide electricity connection to the petitioner on compliance of all formalities within a period of 4 weeks. Within a period of 4 weeks. The disposal. बता दे. Next. Yes.
Couple of matters earlier, but things fell from a lot. I want to show your options as the law is evolving in these items. How it is being used. To that extent, I have taken out on supplementary affidavit only on legal rights.
What, electric connection?
Yes. Let me show you that. Not anything. The copy is served. Let me take it. I started to take instruction after I made myself. The people's address. One of many things are happening in the. We all know about the political. But what is the I do not. This is the supplement, the copy of the supplement.
You know, this is the date petition.
Services on record.
You give me. Come, Kumar. Yes, what is it?
There have been various things happening not by using the power of this. By misrepresenting the law as it is evolving. Kindly take up the supplementary affidavit for a moment. Let me just walk your logic. That is also why I am doing this. I am doing this because we need a fundamental pronouncement of law. Because every circuit that comes, different position of law means that there is widespread support. Now, so far as this person is concerned, I will tell you also very clearly why my electricity connection has been refused on a totally specious ground that the Calcutta has filed a negative report. But let me first show you the law what has evolved. Kindly take the supplementary affidavit. Let's go through it. So first of all, at page 26, this is the extract of the Electricity Act. I just annex section 43. Kindly see section 43. One provides for explanation. Now, this explanation for the purposes of the subsection application means application complete in all respects. Number one, in the appropriate form. Number two, as required by the licensee. Number three. These are the 3 points. This explanation is an amendment in 2007. Special bench was in 2011. Kindly come to page 28. 28. The relevant portion is from page 29. This is the works of licenses rules 2006. Now in 2006, the Electricity Act, page 29, the English one.
Yes.
28 is a Hindi, 29 is the English one. In 2006, there was no definition of the word occupier. So when the full bench heard the case, the full bench borrowed the definition of the word occupier from these rules. I'm not going to get it at 2B. Now, from here, kindly come straight away to page 36. In 2011, the full bench framed 2 questions. I don't know better than me. The first question was occupier. The second question was architect. Court refrained from going into Article 21. Court clarified occupier only in terms of the 2006 rules. Now, in 2011, the administration issues a circular, 5th July 2011, based on Abhimanyu Mazumdar, saying, please provide in light of the High Court larger bench order. This circular is not available in the public domain, but it has been continuing for long, there is no dispute. Now what happened in 2018, page 48. This is one of the last, page 48, and it's a X4. My Lord Justice Pratik Prakash Banerjee had come here on the survey. My Lord was hearing the matter with regard to electric connection. This is one of the last matters where a mandamus was issued. Today I have seen your Lordship issue a mandamus. I tell your Lordship very frankly, very candidly, in most of the cases no mandamus is. An order is passed to consider, but this was one of the last ones. Next page, page 49. But I've seen the JERC regulations of 2018 which came out. Just now, some of them have been shown to your Lordship. But may I visit your Lordship? Pick it up for a moment. In the JERC, no, that copy that was handed up to your Lordship.
Annexure.
Right. No, annexure is only the extract.
Okay.
So, okay, I'll show the extract. Page 49 of my supplementary.
Yeah.
52. This is occupier is now defined. Occupier means the owner or person in occupation of the premises where energy is used or proposed to be used.
Yes.
Kindly note, the word lawful does not appear anywhere in this section.
That after that it has gone.
That's a problem. Now 52 your Lordship has seen. Now kindly see openly at page 15. 5.30. This has just been shown to your Lordship. Point number 7 kindly see. An applicant who is not an owner but an occupier of the premises shall, along with any one of the documents listed at 1 to 6 above, also furnish no objection certificate from the owner. So this changed the position. In the meantime, page 52. A new set of regulations comes, not dealing with new connection, but dealing with premises.
62.
Page 52.
56. Okay. Yes.
Now, this is the Joint Electricity Regulatory Commission Consumer Grievances Redressal Forum. It sets up what is called the CGRF, but this is for grievances relating to an existing consumer. Now, this has certain provisions which I will come to later. What is important is that this is notified. Now, don't forget the notification date at the bottom of page 54. September 2019. Right at the bottom of the footnote.
Page 54.
54.
Okay.
Right at the bottom, footnote number.
30 September.
No, 30th September is the consent date. The notification date is 11 September 2019.
Yes, 11 September.
Right. Now, kindly comes to page 82. This is the notification issue 31st December 2020 by the Central Ministry of Power, where they frame the electricity rights of consumers. In the rights of consumer rules, kindly see on that page 2K.
Yes.
Again, occupier is defined.
Yes.
Thereafter, in this particular notification, various new provisions are introduced for the interesting one, which I beseech your Lordship to see, page 89, number 15.
Yes.
So rule 15 says grievance redressal mechanism CGRF is to be established. So 2019 JERC said it. Now 2020 central government is saying with the electricity. Now my lord comes to page 92.
89 what say? What do you want?
89 has the
Grievance redressal mechanism.
grievance redressal rule 15.
Correct.
Now my lord kindly comes to page 92.
Yes.
Now this is the notification 28 June 2023. The Andaman administration sets up the CGRF.
Page.
Page 92. Annexure S8.
Yes. 23.
So complying with 2019 JRC and 2020 central government administration creates a CGI. Mr. Ravichandran, Mr. Narendra Baroi, Mr. B.K. Thomas. I think Miss
BG.
Now can we come to page 94? After this CGRF is created, a new circular comes up. Now I know this circular we don't have, but I've got the extract from an order of the CGRF. I'm going to place that order as well. Can you see the extract at page 84? Now here, the CGRF is 14. Second paragraph, the Anti-Recovery Administration circulated a circular number 4-3/21/2015 power dated 9/10/23 4. Now A, the applicant must be residing in encroached revenue land only, shall not be applicable for encroached forest area as per order of the Supreme Court and so on. This is a clear government order. Then B, applicant must not be a government servant. C, electricity shall be provided only for domestic purpose, whereas application for commercial industrial activity under encroachment shall not be given. D, procedure for issuance of new connection. Now I am on this. Now D says number 1, application for new connection. Number 2 is what is falling from your budget. The application shall be provisionally accepted. And the application shall be forwarded to the concerned revenue authority on confirmation whether the applicant is in settled possession or not, as defined in the judgment of Pune. Then 3, after confirmation from concerned revenue authority, the application shall be formally accepted and processed further in accordance with JRC 2018. But JRC 2018 says, apart from JRC regulation, nothing more is required. So this circular is created in violation of the full bench order. It is created in violation of the JRC regulation. And it is created as a whim and fancy of an official of the rank of Assistant Secretary power. Now kindly see the ridiculous nature of this.
What is this?
This is an extract of the order. Because this circular has never seen the light of day. This is the only way I could get that portion. But I will show you now. Next page, 85. From here it's logical get. This is a proceeding of 2023. I not going to go to the date very carefully. On the top, this is Gita Rani Mato. Page 96 is the order. 95 is a forwarding.
Yes.
Now kindly see here the case reference number CGRF 303-2324. 21/11/23, date of hearing 28/11/20, date of order 11/12/20. So December 2020. Now here your lordship will get the background of the case where this lady applied for power, she did not get, and after she went to the court. And the fourth portion that I have just referred to, my lord will get that court in this order. Now, no, I'm sorry. That quote is in the second one. I'm showing you much before. Okay, page 97. 97, reply of the respondent licensing. I'm sorry, it's not a very great copy. This is what is available. Now the AE has submitted paraphrase reply. In the second paragraph, at the last 3 lines, the application was forwarded to the Tehsildar. He did office secretary so and so for stating confirmation as per Andaman and Nicobar circular number, again that same circular. The confirmation of Tehsildar is not received with office till date. As and when the confirmation of the sector is received from Tehsildar portal, the case of the applicant will be processed further. This is each submission. Now, my lord, can we see the finding of the here?
Yes.
Page 99. Last paragraph, forum observation.
Yes.
The forum, looking through the documents submitted by the respondent, meticulously and also statements submitted before the court, the complainant, by the complainant, who had applied for video online application of so and so, dated so and so. Supporting documents, Aadhaar card, affidavit, undertaking declaration, etc. Licensing respondent failed to provide the due to lack of jurisdiction from the Andaman and Nicobar administration. What it means, I don't know.
License respondent? Failed to provide new connection due to lack
Failed
of
to provide new connection due to lack of jurisdiction from the admitted requirement. I don't know. Next one. The forum going to the paradise comments reply submitted by the AE HQ stating that the JE inspected the premises and found violating and nothing was not done. Whereas in the counter reply, complainant stated respondent licensee could not be informed orally or in writing about violating and earthing, etc. Apart from this, we have completed the violating and earthing. Earthing, violating, we are not interested. Next paragraph. The forum going to the paradise comments reply submitted by the AEHQ stating that the circular dated 9/10/23 was issued by the Assistant Secretary Power, Air and Administration, wherein it was said that confirmation could be obtained from the concerned Tehsil Revenue Authority against settled possession of income's land. The complainant submitted in her counter reply. As per direction of the Honorable High Court Department, in a circular dated 25/4/23, released the elected petition till July 2020, as per procedure practice in a circular dated 5/7/2011. This is the old one without obtaining any confirmation regarding settled possession from the Tehsil Revenue Authority. But now, the Assistant Secretary Power issued a circular dated 9/10/23 to obtain confirmation from the Tehsil Revenue Authority, which is completely a violation of the Supreme Court and High Court order. The forum observed that the respondent licensee failed to comply should be complied. Comply JERC regulation number 18 for providing electricity connection as a deadline. The complainant had applied for online electricity connection on first. Later a month, the AS Power issued a circular on 9/10. So my lord, see, this is the cutoff. Because of this application, that circular has never been published in the public domain. Now, the court, I can't call this the forum, considers the entire matter and kindly comes to pay 106 onwards.
Oh, lengthy order.
Lengthy order. And kindly see what they do. That is most important. Page 106. They are laying out the provisions of JERC 2018. Then they are considering Supreme Court order. Then they are considering High Court full bench. And after considering everything from page 106 up to page 111, the tribunal says you, Assistant Secretary, have no authority to issue this violating 2018 JERC. We are quashing a circular right. Kindly see page 111. Hence, it is ordered. Number one, the respondent licensee submitted a circular dated 9/10/2003 issued by Assistant Secretary Power is seen not in accordance with JERC regulation for issuing new connection, hence the is false. This order has never been there. Now, although it is false, it is being represented before the court by the authorities that this circular exists. This we will follow, and on this ground, all electric connections are being refused. And I will show you more. What fell from your concern about corruption, this is what is the tip of the iceberg. I will show. Now, can we see number 2? The respondent licensee is direct to provide electricity. Number 3, not important. 4, not important. 5, to cooperate. 6, it is made clear that it will not create any right or equity that is
Already there.
7, respondent licensee is directed to follow processing of application form after receiving the application for new connection as per JERC regulation 2018 under section 5.35. Then 8 is not important. 9 is more important. The respondent licensee is directed to follow JERC 2018 and 2009 standard of performance for providing new connection as per norms and guidelines, which is not done in this case. Then after that, kindly see 11. The respondent licensee is directed to provide proper special training to all staff regarding electricity code 2018 to deal effectively and consumer efficient with consumer. Now, this is not an order in party, this is an order in rem. Then 12, compliance report. 13, non-compliance of the forum order shall be considered as violation of the regulations of the commission. And this was directed to be sent to the SE for compliance and notice for going forward. That is at page 113. So the SE has full knowledge of this order. Now kindly see page 114 what happens. Now, one circuit bench comes to the island where his lordship Justice Kesarmati was hearing the matter. With all humility, may I say this: the petitioner's advocate first day turned up. His lordship said, "What will you order? No, you brought the going to hear them." Thereafter, petitioner's advocate never touched it. His lordship proceeded to hear the matter ex parte. And ex parte hearing was done with 3 submissions of the respondents. What are the submissions? Number one, that JRC 2018 requires a no objection certificate from the owner of the premises. So since all land belongs to the administration, every electricity connection you go and get no objection from lieutenant government, then you can get electricity connection. Point number 2, alternative remedy is why? Because you have now got CGI. Point number 3, Abhimanyu Mazumdar wrong. Single bench says Abhimanyu Mazumdar wrong. Why? Because each Abhimanyu Mazumdar, the portion which was pasted from Electricity Act, that extract of section 43, that amended explanation was not. Whoever typed the order took a copy of the book, which was not amended. Although Abhimanyu Mazumdar considered occupier, so the court comes to the conclusion Abhimanyu Mazumdar is not good law. They have not read the statute properly, section 42. They looked at the amended book, therefore the court was not. And single bench says, full bench is no longer applicable in these arguments. Now, the order is a detailed and very exhaustive order. The only difficulty is this order did not consider various other things. So the next circuit bench which came, page 139. Now this is a very presided Justice Professor Calcutta. My lord sees the matter. And for some reason, that judgment is not shown to his lordship. And the state shows it. The judgment instead turns on a different. The judgment says that so far occupier is concerned, this is a settled matter. And so far rest of it is concerned, electricity is part of the fundamental right to life, Article 21, which answers Abhimanyu Mazumdar's unanswered question. So the lordship says all your alternative remedy, JERC, whatever you say, it can't overrule Article 20. So even if the JERC regulation says that you need no objection of the owner, Article 21 fundamental right, JERC can't override it. You can't give such an interpretation to the statute that allows further violation of the fundamental. And lordship interprets the law to say that Article 21 means we will give electricity connections. But the problem is, you now have a full bench, which my lord will not take the other bench. In violation of judicial discipline, the single bench is saying is wrong. It's now another single bench is taking a different. So the matters came out together with the next circuit, which is at page 148. Justice Orindam Mukherjee. And his lordship says, I am going to harmonize everything. And he considers Abhimanyu. He considers Santosh. Santosh is which one? Justice Calcutta. And he considers Sushila.
That Justice Bhattacharya.
And his lordship says, yes, it is true that Abhimanyu Mazumdar was in 2011. The law has evolved. In 2018, now you have new definition of occupier. Oh, one more thing, Santosh said that Abhimanyu Mazumdar is wrong because work on licenses
Not taken into consideration.
has nothing to do with new connection. So lordship says, very good, that has nothing to do. But 2018 JERC specifically says occupier. It doesn't say lawful occupier. Therefore, Abhimanyu Mazumdar is still good. But the lordship cannot, being in the single bench, set aside the other. So now you are three. Now what happens is, this lordship reinstates Abhimanyu that this is a good law. Because the single bench could not have set it aside. Then his lordship reinforces to shift. That's the subject petition. That Article 21 is the good law, this is the correct law. And then his lordship goes on to consider all of this and give it on. This is MS Rachin. This is the report written. Now we have to come to page 152. Now this judgment, I can see the date, that is very important. So, Santosh is March 24, Sushil is June 24. Rajendran is September 24. 3 month intervals we are getting them. Now, that is September. In October, CGRF does a new case. Now, before your lordship starts reading, I would beseech your lordship to come back to the earlier CGRF order which I showed, page 86. Now compare the two, and I will show you lordship something extremely astonishing. Page 96.
Yes.
Who are the members? R. Ravichandran, chairman. Right on top.
Yes, yes. I got it.
Narayan Chandra Bhargavi, member. B.G. Thomas, independent member.
Correct.
And my lord will find there was in this what turned the case. Kindly see page 111. Because administration said let there be a policy decision for improvement plan, let administration frame a new policy. Page 111, top paragraph. While the independent member do not agree to the point of making a policy decision for encroachment cases of Andaman and Nicobar Islands, as there are precedent decisions by Honorable High Court and Supreme Court protecting the basic rights of the citizens of India. So independent member said what? There is no need for any policy. Law is clear. Supreme Court has said, High Court has said, for what we want policy. And the circular was quashed. Now matter comes to page 152.
Yes.
But page 152.
They let the independent.
Yes. And now what they do? The
Same.
same circular which was quashed
Made implement.
relied on immunity. Kindly see assistant engineer portion, page 153 bottom. Reply of the respondent licensee.
Yes.
The assistant engineer submitted paragraph comments. Now the next page, this is that page from where I took that quote.
Quote unquote.
So quote unquote circular is okay. They are relying on the same circular which is quashed by the
Already passed.
persons. And then it says that Tehsildar's letter is there, blah blah blah. In 2024, after CGRF 2023, High Court ordered against two orders in favor of Purve coming back to life. They say the case is dismissed without any merit. Because Tehsildar report is not. And Tehsildar report is taking up to 6 months. And I not can imagine the situation.
But how this court can consider this all?
I'm getting a question. Now I see what is the current official position. Official position. Page 159. This is an order of refusal of electricity to the petitioner's close parent.
Sadhana Viswas.
Mature will kindly see the third paragraph. And whereas, as per extant provision and structural procedures, all the received applications towards supply of domestic energy meter connection having involvement of encroachment or government revenue land by the applicants are processed in accordance with the direction issued by circular dated 9/10/20. You stand. Though it was caught. And then it is relying on next paragraph, whereas Honorable High Court at Portland in WPA so and so, some court. So Sushil and Rajendra and Purve have done it. As per their case, we can see they are picking up one judgment, they are picking up what circular. This is the way the department comes. And kindly see at page 168. When the lovely advocate has issued contempt notice saying that there are high court orders. Now these high court orders are not inter se. When you are striking down a circular, you are interpreting the law. This is in red. It applies to the world. So the high court has passed certain orders. The reply PTC, page 168, last three paragraphs. In compliance with the directives of the Honorable High Court in incident matter, and in accordance with the provisions of JERC 2018, as well as Administration Circular 9/2023, it is observed the applicant does not meet the requirements. Thereafter, accordingly, the decision is communicated to the applicant, granting liberty to submit fresh application in connection in accordance with JERC 2018, as well as Circular dated 9/10/23. Then what happened to all the High Court orders? Clarifying the law. And then the last line, with all respect, this is issued with the approval of legal sense of laws, which means they are advised in this situation to follow one judgment and a watch circular. No matter why this is relevant to me, I can take away it. why, as your lordship observing, how this court can look at it. In my writ petition, page 30. This is the application status. No order is served on, only the online status. Application status rejected. Now kindly see the right hand side remark. As your application was forwarded to Tehsildar SVP, then on the next page, madam. For settlement position, we did letter number so on date so. After getting the reply from Tehsildar SVP, we did letter number so. It states to strongly condemn any encroachment of government and granting of electoral fiction to individual who claim ownership of whether the Tehsildar can overrule High Court asking this.
So you ask for the first question.
Now, why I am saying this? Whatever I have submitted so far, nothing is a matter of fact. Everything is a matter of law. Today, we have to argue, I'm not going to argue any of the laws. I'm going to argue the doctrines of administrative law. What is the principle of hereditary? What is the application of the pronouncements of the Honorable? My lord, it is a instrument that let this matter be constant authority to make on judgment. Let the law be clarified that the circular has been quashed by the CGI, which has the jurisdiction. Let it be clarified that MS Rajendran is good law. The administration cannot rely to a quashed circular and by selective memory, the judgment which is rendered in Santosh. I am not saying anything is bad law, but I am saying that there has to be a harmonization of law. But what is the doctrine of prospective overruling? The doctrine says you will not have multiplicity of orders which will create confusion for the government, for the lawyer. How we will advise the client or the general public. But let there be a consideration of the law and let there be a reasoned order regarding the law. Hello, this is my very humble opinion.
Yes. The administration can do that, Mrs. Marshall. Mr. You're not having a control over the administration. You are appearing on behalf of the administration. You're not keeping the control over the authorities. Only the authorities what they are telling you to putting before the court. You being the court officer, you should have the control over the authority. You know, you work with me.
And this is correct. This is full of motor. Your lordship can take cognizance of this.
Because I am taking because it was discussed.
And what your lordship does is following from your lordship, okay, they are sitting and listening simple electricity, that is juniors are appearing. But this is the legal position which no one is putting it all in one place for your lordship to see. Today I am putting it in one place.
Take instruction some day after tomorrow, and I will not give this matter. It has to be settled at once. All the needs to be taken in.
But I have not left out any legal document.
If you want to come with the written notes, not required is the law point. Come with the written notes. What is your instruction? I will give time. You argue on that. How the CGRF once they have once they have taken a decision, how they can implement?
It's not applicable and there.
Then
2024 there.
again, applying that.
They won't be squad.
When it has been caused, how it has been reviewed. Without the review
They
application.
are not under our. They are the independent.
Not, but you have to challenge that. It is our
It what has been challenged.
challenge.
With greatest respect, that can't be done.
No, 2023.
Appeal provision is there and limitation is wrong.
No, he has not challenged. No, I'm telling him they are not challenged.
With the greatest respect to Mr. Mishra, I don't think he knows the entire picture. What is going
You
on.
go, that's what I'm
That's
telling.
why I have this supplementary.
Go through all this.
Wrong.
Go through all this, sit with the administration. I am giving tomorrow one day. Come day after tomorrow, answer all this one.
This is the, it's just to make it simple.
Mr. Kabir, advocate, London senior advocate, appearing for the petitioner, has argued at length and also served the copy of the supplementary affidavit disclosing documents to the to Mr. Satish Misra, who was appealing for the administration. Mr. Misra, raise for redress accommodation to go through the document in by the petition. According cases adjourned, let the matter appear on 9th.
Kindly sort this matter as well.
9th as especially fixed matter.
But let the matter be parted. I have argued for considerable time.
Let the clearly especially fixed matter. I will see.
Keep. So Blair, I'm sorry, my lord, for taking so much time. It's the matter, but this needs to be brought to the attention.
No, that is to be brought from.
And all these materials are there, but it is not brought together in one place.
Let us see what Mr. Mishra can do.
My lord, this will make his.
No, that's why you see that. Sit with the.
Coming from your lordship also, my lord, today I showed your lordship the legal basis. For this.
On the last occasion when I came, I find that I called the officer. They told me we are issued the circular, not required. It will be not rejected. And I think that will follow for the 2-3 months. Thereafter again it is started.
Difficulty, my lord, is that if a bench comes, then in order to Mr. Mr. is not there. Someone says, no, you see the.
That is
You see
the
this.
all the things.
Then the what is the unique?
Okay. Call the next.
Great.
Yes. Yes. Yes.
That it will get to be affected on the opposite side of the
What?
party number one,
Two. That's all.
with respect to the party number two, the council has tried serving 2 times, the service has come incomplete because of the. Like you stated, this is the same address which is there, before.
That is the affidavit of service.
That
Okay. Yes. What is the matter?
similar matter with respect to the.
Acha. Yeah.
And motor vehicle side.
Yes. Yeah. Where is Mr. Actual. Today, Mr. Abdul is not here. His junior is what? Divedi. Divedi. What is his name? Where he is? Item number 18. Just court fee in the MSDT cases. Yes. What is the submission?
The.
Now that's good. Whether the stamp duty is payable or not. Why?
This is not a valid thing, Your Worship.
Hmm.
This is an application of the beneficial legislation.
Hmm.
But when a money is transferred, there is a specific amount that is already allocated,
Hmm.
whether it is for damages or for compensation.
Hmm.
And on depending upon that amount, that will in both cases paid.
Hmm.
But if it is an application and a not, here the amount of compensation is not predetermined. So for the description of what has to be acquired. And therefore, there is no regulation or law which prescribes the amount of what has to be paid unless it's rule which was submitted by the council for the administration, wherein they have submitted that there is which has been claimed after the motor vehicles act. Compliance with section 183 of the motor vehicles act, these items are rules were made. As per the rule 116, the.
There is a rule.
Your Worship,
Rules is there.
but it's not in complete domain. I have been
Notified.
Your Worship, but I have been supplied only one page of that particular rule.
Who has supplied?
Council for the administration.
That's why you want to hear him.
One application of rates. Every application for rate of compensation, rate of compensation, it shall be written in the form and shall be accompanied by 20.
Where from he got? Where is the administration? That I wanted to know with regard to that's why you call the administration whether any rules have been framed or not, because last rule are 1939, we are following the central rules 1939. Subsequently, any amendment was made or not?
As per.
Well, yes, on that time, Mr. Chakravarti was.
There is nothing of the same rule is there,
That's why I want to see how
They are having, they have got from the administration.
when
It's not faster, it's on.
it's coming. Not possible. Proposing. Next. Hmm.
He was there.
So what is that? Who is for the appellant?
He played for because
Where will be the time? Second appeal. There is no junior. He can take he can take and he can argue that. Not take that. But inform tomorrow. If you're not able, then let the junior come and take note of. Yes, next.
related
Items necessary to seeking.
Hmm. Why? What the court will do for the last for 1 week now? No matters. As per prayer made by the counsel for the petitioner, it is adjourned, let the matter appear before the next legal circuit bench. Till 16, huh? 13, 14, 15, 16. Next. Who is the added respondent? For hearing.
Video
13 or 30?
30.
Individual's name has been already recorded in 1990. So, have you not, sir?
Yeah.
Counsel for the petitioner. Counsel for the petitioner submitted. That have you sent? Counsel for the petitioner submitted. The notice upon the added respondents have been sent, but has not received the track report. Accordingly, she placed for time. In view of the submission made by the counsel for the petition case adjourned, let the matter of the next sir. Next. Same. Yes. Is having a notification? Okay. Pass. That's all. Okay, pass. Pass for 18. Pass. Yes, next.
19, 20 and 21 similar matters are all running in one.
So what do you want?
Either both matters can be transferred over.
I don't know.
It makes any difference. Both the courts have same powers. I get this, both matters deals, I can proceed with this matter.
Ready?
Yes, yes. But my other objections are not. They are completely on this file of opposition.
When the case was filed, January 31. Then
I have received this. Draft, second time we take it before the court. Not-
so what can be done?
Whatever you about.
If you
Subject to what you think. Let this all be demanded back. But two matters, same, no reasoning, nothing. This has to be demanded back to the government.
already
On the basis. Already decided two matters.
space of the staircase, under the staircase.
They are running parts of sector here. Professors are here. Lot of it's uncalled.
So that's why if you are going to the market, first you choose this small fish. Then only you go to the big fish. So that procedure has been adopted.
There is one.
Yes.
There is one. There are a lot. They are saying the air side, and otherwise also it is have to construct shop.
Are you accepting the rent? Are you accepting the rent from these persons? No. You are accepting the rent from these persons who have occupied the under the space under the staircase.
Those are for government revenues, they are.
You not file the affidavit.
I can find that.
How soon?
Within 2 weeks. for-
Ma, play.
I have to prepare it, I have to prepare it for waiting, mother.
And the municipal is having good experience. They can prepare one day. Yes, Mr. Jaipur.
I see a lot of passed by this school in the first round, at 59.
59.
This is very useful.
Yes.
But the order was same order was passed earlier also, which had challenged now. The order was set aside, again, the matter was relegated back to the council. Then case 60 came to be passed. Similar reasonings, no independent finding, no reasonings, nothing. Same reasoning, this for the already satisfied. Let them apply their mind, Lord. But is there there are small space being earmarked for running a business shop. It's going to harm anyone, and not any city so-called reason assigned in the order. As if it's a very big palatial building, can you say?
It is pertinent to mention here that petition has not applied for any lawful shops. Moreover, does not having any. Once you are telling that apply for shop and second you are telling that there is no space in the Monpura. Have you got the six
No,
space?
they have applied for the shop. We currently don't have.
No. Page 61, 1, 2, 3, 4, fifth para. In those circumstances, petitioner may apply first with the Portland Municipal Council for allotment, correct, of a lawful shop, and the council shall consider the same strictly in accordance with the rules and availability of the space, subject to any other pending application in accordance with that. This is correct.
But
Now, second, it is pertinent to mention here that the petition has not applied for any lawful shops. Moreover, does not having any vacant lawful shop for the vegetable market in Mount. Illegal occupation under this way inconvenience to the general public. Explore the market such a thing. Yes, why you not applied for?
page 30, not page 50. It's an application for allotment of shop.
Page
55, it should be. They have not even considered this document. Page 50.
when you applied for 2018.
Really? No, and in fact, that is 6 years back. No, in fact, they're saying that they're doing that. But these that they have applied for manage that application is 5, 6 years prior. So the 18 is further.
No, 2022 also. Page 50, 51.
Well, this can be considered.
I am setting aside, sending it to consider this to a representation and giving an opportunity to the petitioner to consider it on.
But I have a small indulgence. Normally, what the council and revenue department does is that they pass an order on Friday. Saturday, Sunday, they take their one. They actually make a document for.
Okay.
This is taken something.
Okay.
We will pass over the budget. We like
So and so suffering for the petition. The petitioner has filed the present date application challenging the order number 421 dated 19th January 2025, where the secretary Vijayapuram Municipal Council has rejected the has passed an order directing the petitioner to remove his shop set up illegally under the space for staircase within 2 days from the date of this order, telling which Executive Engineer -1 within vacant works is directed to execute the order at the cost of the petitioner and file compliance report. Full stop. Concept for the petitioner, full stop. The petitioner had drawn the attention of this court to the order dated 9. This court find that in one paragraph of the order, it is recorded that the petitioner may apply fresh with the Port Blair Municipal Council for allotment of a lawful shop room, and the council shall consider the same strictly in accordance with the rules and availability of the space, as also subject to any other pending applications in accordance with the law. In the very second paragraph, it is recorded that it is pertinent to mention here that the petitioner has not applied for any lawful shops in SVPMC. Full stop. Moreover, SVPMC does not have any vacant lawful shop for allotment at vegetable market at. This could find that the Secretary Municipal Council is of the view that the petitioner has not applied for lawful shop in the SVPMC. But the petitioner has disclosed two representation dated 2012-2018. It is of the petitioner.
Right. Okay. Fine. First bottom,
Petitioner, Kerala.
51 and 55.
Representation dated 2012-2018 and 13-2022. Praying for requesting for allotment of earmarked respective shops room at Mohanpura Vegetable Market. But the Secretary Municipal Council has not considered the representation made by the petitioners dated 20 December 2018 and 13-2022 and passed the impugned order. Considering the above, this court find that the reason assigned by the Secretary Municipal Council holding that the petitioner has not applied for any lawful shop in the SVPC is contrary to the document available on record. Accordingly, the impugned order dated 421 dated 29 January 2025 is set aside and passed, and the matter is remanded back to the Secretary Municipal Council to consider it fresh by taking into consideration of the representation made by the petitioners dated 2012-2018 and 13-2022 available at page 50 and 51 of the presented application. And after giving an opportunity of personal hearing to the petitioner to pass a reasoned and speaking order within a period of 8 weeks in the date of receipt of this order. It's made clear that after passing the speaking order, if it is against the petitioner, the authorities shall not take any action against the petitioner for eviction within a period of 1 week from the date of hearing. WPA 55 of 2025 is disclosed. 19, 20, 21, all three.
Yes.
वो 3 में ना वो हल्का डेट देख लेना नहीं ऑर्डर नंबर
Appearing for the petitioner in this matter. On the last occasion, the respondents prayed for an opposition, an opposition in favor of the KERC regulations 5, clause number 5.34.
30 power of attorney yes.
No objection from the owner of land. Electricity denial. This order not had case, even Raglan might be on the court. Parents order dated April 11, 2025, he said law was itself set aside for the purpose of granting of electricity. But still may not be opposition yet shall not be filed. And for additional remedy.
Who is appearing? Where is Mr. Mishra? पास हुआ मिस्टर मिश्रा? हाँ पास हुआ मिस्टर मिश्रा बिल्कुल इसी में
Supplementary condition approval from So the order under 20 which are challenged find at page 74. Page 74.
what you have prayed for?
That's the great, till this food is decided. The order needs to be state for its operation. Put the way,
Page
page, the order of the challenge, page 70, 74. If I had challenged before this court at the first instance in a writ petition, and so that order. It was disposed of.
directed to remove the structure notice under section 202 within a period of 7 days.
So then I challenged that.
Hmm.
So this court
Hmm.
at page 33. Page 33 and now kindly page 34 last paragraph. Page 34 last paragraph. The impugner has been found in exercise of authority under regulation 204. Andaman and Nicobar Island Land Reform Regulation 96. The said regulation itself provides an avenue to the person agreed to take steps toward this issue. Then I filed this suit. I filed this suit for to start my claim to start at page 36. Page 36.
Yes. 36 you filed the suit.
Has been filed pursuant to liberty granted.
When you filed 2025.
At on 17th April 2025.
Hmm.
Even the additional action challenge there, 82 was sought for, leave was sought for, it was granted, should have been registered.
Hmm.
Then not now, the Tahsildar says since there is no stay, I cannot protect mine. He is behind me like anything.
Who are you?
I am the person who has occupied the subject land, say government land, along with my recorded land.
You are also recorded. You are also
20 is recorded.
you are also having the recorded land.
Recorded. Adjusting to that, I will enforce the government review land. So
Correct.
came to be passed.
Correct.
I filed a petition, this court said the court is report.
Hmm.
Once you register and it is not given.
Hmm.
Tahsildar is every now and then is attending.
Where is the fresh notice?
I issued the notice at page 82.
No, whether the Tahsildar issued any fresh notice? No.
Notice has been given, but I informed the Tahsildar about the pendants. Pay it to accept the sign,
Hmm.
but it should be filed.
So why you not filed it on 13 and 1 and 2 there?
Was 202 not.
Correct. Correct.
Protection.
Correct. But you could have been filed there for 13 and 1 and 2.
Against government is still not done and.
But if 80 you dispense with,
Expensive.
then notice might have been served. Where is the dispensation order? Where is the dispensation order?
Next one. It's at page 37. Page 50. Page
Page
50.
50. Where is the order? Have the dispensation is granted, then automatically they have.
Registered. Kindly mention these two orders on this. Active on the point. 2.5. The Tahsildar was directed not to carry out the issue. Active on the point. Even the statute is very clear on this. It's very clear. Right.
You are not having that order. Hotel Bay Island.
Clear, yes, sir. This.
That is the best order.
That has been reflected in the order.
Do one thing, you should notice, come tomorrow, I will pass on. No, here, I talk to the PP, the GP. The petition has moved the present affidavit application as unlisted motion with the prayer for urgent relief. This court has considered the submission made by the counsel for the petitioner, but this court of the view that one opportunity should be given to the government or to the responding authorities. According, the petitioner is directed to serve the copy of the writ application to the to the government pleader in course of the day. Let the matter appear to court.
It's at Mayavan. One day, no persistent, because I mean, informs.
Let the matter appear tomorrow.
No persistent.
In the meantime, the Tahsildar Mayabanda
Yes.
is directed. Tahsildar Mayabanda, that is response number 3. Response number 3 is directed not to take any pursuant steps in the petition till tomorrow. Under the heading emotion. Yes. Password में तो कोई है? हाँ?
I think
Which for the authority? Still sees there. Still sees in court number 1.
very short method.
Yes.
The authorities have decided that penalty has to be imposed upon the petitioner for certain acts. That is, minor minerals with the Minor Minerals Act, they have decided that this much amount of penalty is imposed. They have done the inspection, they did everything, no inquiry, nothing, whatever it is, your worship, it's an appealable order. I have filed an appeal before the appellate authority, my appeal is pending. Now, your worship, in order to recover the amount, whether they can pressurize me by stopping my crusher unit to the.
Where is the appeal?
The appeal is page number,
28.
yes, your worship.
Before the governor,
Yes, yes.
Lieutenant Governor.
Yes, as per the rule.
It is still pending.
My condition.
When you prepared an appeal?
Recently, that is preparing, along with.
30th June.
Yes,
And when the order passed?
was passed on
November
18
20.
December and 2nd April.
Yes.
Because initially no opportunity of hearing was given. I came before the honorable court. Thereafter, your worship, the commission passes. My only submission is that, your worship, as per the minor.
Mines and minerals.
Minerals rule, it is clearly given under section 48, how the amount is to be recovered. That is through land revenue.
No, that has been recorded in the Deputy Commissioner order.
Clear, but how the Tahsildar can stop my crusher by saying that only I will be permitted to operate by crusher once the amount is reduced. How can he see so? Same thing has been done by Pollution Control Committee also. They have suspended my license by saying that penalty has to be deposited, then only the license will be recalled. They have suspended my license. How can it be done, your worship?
Yes, where is there?
Is this the manner to execute the order?
Can you dispose of? Yes. Which matters is appearing before the court number 1? Item?
It is not legal. But come to court.
And item number 6 also. Which item number 6? Okay, item number 3. When the civil come, okay, let us pass over if civil come. Yes, call the item number 7, 6. Item number 6. Yes.
It's 12.
Yes, madam. You are disputing with regard to his ownership of the property. Record and all.
Always 1.5 years.
The petitioner has filed the present application, praying for a direction upon the respondent number 2, that is the Tehsildar Vijayapuram Tehsil Southern Vijayapuram Tehsil Southern to demarcate the land bearing survey number 38 by 13, measuring an area of 0.02 hectares, situated at Bibliton village under Fordwell Tehsil Southern. Petitioner submit that the petitioner has made the representation on 2nd February 2024 before the authority for demarcation of a landed property, but till date, no demarcation has been conducted. Yes. How much time? 2 weeks? Huh? Police, the police. Council for
If you can check, within 25 days, been completed.
council for the petition submit that the respondent authorities have issued the citizen charter, wherein it is noted that the demarcation shall be completed within 25 days. But in the present case, more than 1 year has been passed. The authorities have not demarcated the landed property of the petitioner till date. Ms. Babita Das, Leonard Government Pleader, appearing on behalf of Government Pleader, submit that some time is required for demarcation of the landed property, as notices is to be issued to the site plot holders so that the demarcation can be made in presence of the site plot holders to avoid any future complications. Would the Leonard Council for the respective parties peruse the materials on record. This court find that the petitioner is the recorded tenant of the land bearing survey number 38 by 13, measuring an area of 0.02 hectares, situated at Bimlitan village under Vijayapuram Tehsil, South Andaman. The petitioner has applied for demarcation of a landed property by an application dated 2nd February 2024, but till date, no demarcation has been considered. Considering the above, the Tehsildar Fordwell Tehsil and Vijayapuram Tehsil, Sri Vijayapuram Tehsil is directed to demarcate the land of the petitioner after issuance of notice to all the site plot holders within a period of 4 weeks from the date of communication of this order, and to supply the copy of the demarcation report to the petitioner within a week thereafter. WPA number 7 discount. Yes. Which rule?
I have talked to the state transport authorities. They have framed the rules under section 176 of the code.
Where is the rule?
But I was telling you the extent of the rules. I told them to give me a test once.
Ah.
Not them, but what.
That's why that I want, because all states having, even our West Bengal is having the rules. Gujarat is having the rules since 1977. They have framed the rule from the old act.
What is uploaded there?
But, yeah, please see that. That's why on the last occasion I requested Mr. Chakravarti. See that? Not today. Gula, fine. Yes, अच्छा उसका पासवर्ड दे. Item number 8. 18. अरे पासवर्ड बोला था ना. पासवर्ड वो तो सेम 18 और जो 11 है ना, वो दोनों को एक साथ में रखेगा. 18 और 11 को एक साथ रखेंगे कल. पास हुआ 3. अरे बाबा, call the 3, serial number 3. देखो कोई का बता. Yes, not received. But only the Tahsildar, once kindly come to the DC order, page number 20, 220, operative portion, second paragraph, penalty amount shall be deposited with the cashier, Southern within 7 days from the date of receipt of the order. TR5 of the deposition amount shall be produced before the Tahsildar Vijayapuram. In case failure of complying the necessary entry shall be made in the record of rights of the concerned holding holder, violator of the violator, and the fine amount will be collected areas. Correct? So if it is so, how the Tahsildar can pass this order? Kindly come to 36. Only he can record, he can recover from the land revenue. Kindly sir, page 36, second last line. Till such time as the penalty amount is paid, stone crusher unit is situated at so remain closed and remaining how? The DC has not given that power to him. First thing. Second thing, then how this pollution control power is withdrawn? Oh, the DC has not stated. It has to be recovered from the land revenue. If he has not paid, you take appropriate step for recovery. I am not staying with regard to the DC order, but with regard to the DC order and this Tahsildar order and the pollution control, how they can do this? So, and they have already prepared an appeal. They already prepared an appeal. So I am staying this order till the disposal of the appeal pending before the governor. The petitioner has filed the present application challenging the order passed by the Tahsildar, Sri Vijayapuram Tahsil, dated 31st of December 2024, wherein it is recorded that wherein it is directed, wherein the petition is directed to deposit the penalty amount to the cashier, district office, South Andaman at the earliest, and produce the copy of DR5 before the undersigned, full stop, till such time as the penalty amount is paid, stone crusher unit of the petitioner situated at Calcutta village shall remain closed. And the Tahsildar directed the revenue inspector of circle number 5 and the Patwari circle number 14 to close down the operation of crusher unit until concerned unit with immediate effect until due fine amount is paid by the petitioner. Simultaneously, the member secretary, Andaman and Nicobar Pollution Control Committee, Department of Science and Technology, has issued a letter dated 29th of January 2025, informing the petitioner that the suspension of consent to operate within bracket CTO issued for operating stone crusher unit at Calicut village, Sri Vijayapuram, South Andaman, is withdrawn, is suspended. Full stop. Counsel for the petitioner submit that the DC by an order and the Deputy Commissioner, South Andaman District, Vijayapuram, Sri Vijayapuram, had passed an order. On 2nd April 2025. No. Where is the DCO? On 18th October 2024. Passed an order on 18th October 2024. Directing the petitioner, the penalty amount shall be deposited with the cashier, district office, South Andaman within 7 days from the date of receipt of the order. Full stop. The TR5 receipt for the deposition of the fine amount must be produced before the Tehsildar, Vijayapuram. Full stop. In case of failure to comply, the necessary entry shall be made in the record of rights within bracket ROR of the concerned holding of the violator, and the fine amount will be collected as arrears of land revenue, as prescribed under the Andaman and Nicobar Island ANI, LR and LRR 1966. Full stop. Counsel for the Mrs. Anjali Nag, Leonard Senior Advocate, appearing for the petitioner, submit that the Deputy Commissioner has categorically has directed that if the petitioner failed to pay the amount, failed to deposit the amount, necessary entry shall be made in the record of rights of the holding, and the fine will be collected as arrears of land revenue as prescribed under the regulation. But ignoring the order passed by the Tehsildar, passed by the Deputy Commissioner, the Tehsildar has passed the order directing the petitioner to pay, directing the petitioner to pay the penalty amount, failing which the stone crusher unit situated at Calcutta village will be closed, and he directed the concerned authority to close down the operation of stone crusher, which is not within the jurisdiction of the Tehsildar. She further submit that the order passed by the Pollution Control Authority by suspending the license granted to the petitioner is also without the authority, as the Deputy Commissioner has not passed any order either for closing down the crusher unit or for suspending the pollution control certificate issued by the concerned authority. Counsel for Mrs. Nag, Leonard Senior Advocate, further submit that the petitioner has already preferred an appeal against the order passed by the Deputy Commissioner before the appellate authority, and the same is pending before the appellate authority. Per contra, the government pleader, Babita Das, government pleader, submits that at the petitioner has failed to comply with the order passed by the Deputy Commissioner, and as such, the Tehsildar has directed the petitioner pass the order for closing down the crusher unit. She further submit that as the Deputy Commissioner has passed the order, accordingly, in compliance of the order passed by the Deputy Commissioner, the Pollution Control Authority has suspended the certificate issued to the petitioner, and thus there is no wrong committed by the authority by issuing this order. Had the learned counsel for the respective parties peruse the materials on record. The Deputy Commissioner in its order dated 18th October 2024 have clarified that if the petitioner failed to comply, failed to pay, and failed to deposit the amount within 7 days, the amount will be recovered through the will be recovered as areas of land revenue as prescribed under the Andaman and Nicobar Island LR and LRR 1966. The Deputy Commissioner has not passed any order directing the Tehsildar for closing down the crusher unit, and also not directed the Pollution Control Authority for suspension of the pollution control certificate issued by the authority in favor of the petitioner for running the crusher unit. Considering the above, this court find that the Tehsildar as well as the member secretary Andaman and Nicobar Pollution Control Committee have passed the impugn orders without any authority by interpreting the order passed by the by wrongly interpreting the order passed by the Deputy Commissioners of Andaman District. This court also find that the petitioner has prepared an appeal and the appeal is pending before the appellate authority. In view of the above, the impugn order passed by the Tehsildar dated 21st of December 2024, wherein the petitioner has been directed and wherein the stone crusher of the petitioner has been closed on and the pollution and the order issued by the Pollution Control Authority wherein the certificate has been suspended is stayed till the disposal of the appeal by the appellate authority. As police stop. Nothing remains. What remains? Yes, what remains? Police stop. In view of the above, the WPA 301 of 2025 disposed of. It is made clear that if the appeal goes against the petitioner, comma, the Tehsildar as well as the Pollution Control Authority shall be at liberty to take appropriate steps if any order is passed by the appellate authority. By the appellate authority. Yes. Item number 22.
So my action
Hmm.
was denied on the ground of basis of the AERC regulation clause 5.30.
Yes, Mr.
That has already been dealt in the judgment passed by justice proposal. So same order can go.
Have been set aside, but there is no ground for them on the
The petitioner has filed the present application praying for grant of electric connection. Where is survey number? Nothing. What? Where is your survey number?
You know, it is there is no survey number because it is an enforcement plan.
Without survey number, all government land or private and all survey number. Where is your affidavit?
My application is
Huh. 1 by P.
yes.
1 by P is
One of the is survey number.
how it can be identified.
It is a big chunk of.
Subdivisions.
Cannot.
But Miller encroachment may.
I don't know anything about the island. क्या बोला? Electric connection in her is in her residential house. Residential house is standing on survey number 1 by P, measuring an area of
Area of your
measuring an area 200 square meter, situated at ward number 18, Irshan Nagar. Atampad is the village, Ramani village has come. Atampad? No, yes. But you are taken as a village Gadacharma. See, come with the total description. You kindly come to the page 14. Survey number 1 by P, locality Atampad, Birsa Nagar, ward number 18, village Gadacharma. Birsa Nagar is another village. And come to your affidavit. Atampad village. Atampad is a village, revenue village. Then
That is called as item by local.
no, some part is the Gadacharma.
Yes, from Balika Nikesan, it is there.
Garage. Yes, which one you will provide tomorrow? You will be in difficulty, sir.
Miller other part is right. Because the same has been recorded in the ration card.
Ration card survey number. Six, lot number 18, Atam Pahad, Birsa Nagar, Garacharma village. Garacharma village. Council for the petition submitted. The petition till date, the authorities are not provided the electricity connection. On the unequal citizen, council for the petition submitted. This is the impugn order.
Yes.
Council for the petition submitted. The assistant engineer, dash Roman 2 headquarter, electricity department has passed an order dated 14th February 2025 by rejecting the claim of the petitioner on the ground that the petitioner has not disclosed the registered power of attorney in terms of clause 5.30 of JERC regulation 2013. Full stop. Counsel for the petitioner submit that has relied upon an unreported judgment passed by the coordinate bench of this court in WPA / 213/2005 dated 11th April 2025, wherein this court has held that clause 5.30 does not in any manner fetter the right of the occupant to get electricity connection. So the counsel for the petition submitted. The judgment is squarely applicable in the present case, and he prays for setting aside the order passed by the assistant engineer and a direction upon the authority for grant of electric connection. Per contra, Leonard, Mr. Satish Mishra, Leonard advocate appearing for the electricity department from Andaman Nicobar administration submitted. As per the JERC regulation, submitted the petitioner has applied for grant of electric connection on the basis of the power of attorney. And as per the J regulation, clause 5.30, the power of attorney is to be a registered document. But the petitioner has not, but the power of attorney with the petitioner has relied upon is not a registered document. That's it. And as such, the assistant engineer has passed the order rejecting the claim of the petitioner. At the Leonard counsel for the respective parties review the materials on record. This court find that the petitioner claims for grant of electric connection in the government encroached land. As per the case of the petitioner has occupied a government revenue land and had constructed a residential house and has applied for electric connection. Why if it is a government land, why the power of attorney? If it is a government land, why the power of attorney?
But the no objection have not been granted by the judge. Was like for
Why the power of attorney? You have applied for why power of attorney? Then
right for objection from the Calcutta. Because electricity department demanded it fully, was not there in the online answer. The requirement was not there in the online.
So then I have to decide the other matter along with you. Mr. Kabir is arguing the matter. It is that. वो matter कब तक परसों let the matter appear on 9. Other matter is there. I will. Correct. That's why I will dispose of both the applications.
This order. Great.